Bonjour, hello, and welcome to our webcast for May 31, 2019.
Yeah.
My name is Christian Debré, and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet.
Hello.
Also joining us, this is Taylor Ayotte, our outreach coordinator and policy analyzer. So our goal, okay, Toujours Vivant, Not Dead Yet is a non-religious organization by and for people with disabilities and our allies. Our goal is to inform, unify, and give voice to disability rights opposition to assisted suicide, euthanasia, and other ending of life practices that discriminate against people with disabilities. Today's topics, we have two. The first one is Guardianship revisited. The second one is Cadotte sentenced to 2 years for
manslaughter.
Manslaughter.
Sorry.
There
I got
was a
notification.
pop-up going out over the text. So Amy will help us through those
Yeah,
subjects.
Amy will do her best anyway.
Yeah.
Amy has told
Yeah,
Amy
sorry.
is not all present, so
But she's nice and she has a very nice necklace.
necklace.
Oh yes,
Sorry, my English is
your fashion sense.
That's okay. Okay, so Guardianship revisited. At the end of April, we discussed the United Nations Special Rapporteur's visit to Canada. In the statement summarizing her findings, Catalina Devandas Aguiar said that persons with intellectual and psychosocial disabilities are systematically denied their legal capacity through substitute decision-making regimes such as guardianship and curatorship, which affect nearly 21,000 people in Ontario and 34,000 people in Quebec.
2 minutes.
Oh yeah.
Yeah.
Ontario is Quebec is 2/3 of the population of Ontario, and we have 1/3 more than Ontario. So if you do the calculation, we do have almost
Too
twice as much by population as Ontario.
Yeah.
Something goes wrong over there.
And that, I think, is symbolic of the paternalistic nature of the social services in Quebec.
Yes, I feel very paternalistic.
Well,
Sorry.
anyway, yeah, it's kind of how the system works, and it's not good. I think Quebec should really be ashamed of that statistic. A few years ago, the Canadian Association for Community Living released a policy document, to which we have linked, explaining that under substitute decision-making systems like guardianship, people have no power to make, control, or even influence decisions about issues that are important to them. Substitute decision-making arrangements often contribute to the perception that the individual is not a person, but rather an object to be managed by others.
An object.
Right. And that's one
Not
of,
anymore a people, an
Right.
object.
right. And that's one of the things that people talk about when they talk about the medical model of disability, is that disabled people are objects of medical care, as opposed to the social model that talks about the circumstances disabling people, and people being the operative word here. Okay, so Ms. Devandas pointed out that successful supported decision-making programs exist in British Columbia, although they lack a legal framework that would allow them to be offered on a larger scale. So Canada has been involved in creating these ideas, but hasn't implemented them. She points out that all provincial and territorial legislation on legal capacity contradicts Article 12 of the Convention on the Rights of Persons with Disabilities, CRPD. Supported decision-making is an alternative to guardianship that respects the person's rights, allowing them to have the final say in as many areas of life as possible, contrary to common fears. True supported decision-making occurs when as an article in the Psychiatry, Psychology, and Law Journal states.
A very important news for Medical Association.
The individual is assisted to become aware of his or her responsibilities and of the implications of his or her choice. So basically, it's a cooperative process where the person has somebody to help them come to a decision rather than the other person saying, this is what you will do. While supported decision-making is most well known in the context of intellectual disabilities, people with psychiatric disabilities benefit as well. The journal article notes that Canadian procedures are not designed with extreme mental stress in mind. Having difficulty making decisions doesn't mean that a person should be deprived of the right to direct their life. That's important.
Yeah.
Okay, so here's what Article 12 does. Article 12 of the CRPD calls on member states to do the following: to reaffirm that persons with disabilities have the right to recognition everywhere as persons under the law.
A person is a person is a person.
Right.
Whatever happening.
Right. So regardless of whether the person has intellectual or psychiatric disabilities, the person is a human being and has equal rights and responsibilities under the law.
Yeah.
They also call on member states to recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. And again, the idea is, how do you exercise that legal capacity? That's the key. Provide access by persons with disabilities to the support they need or they may require in exercising their legal capacity. So help them out to do that if they need it. Provide for appropriate and effective safeguards to prevent abuse in accordance with international human rights law. So, and we'll talk about that in a sec, a little more detail. These safeguards must ensure that laws related to decision-making respect the rights, will, and preferences of the person, that the laws are free of conflict of interest and undue influence, that the measures are proportional and tailored to the person's circumstances, that they apply for the shortest time possible, so they're not never-ending.
Because now, to get out of a tutorial or
to get out from under guardianship, it's very, very, very difficult. And that they are subject to regular review by a competent, independent, and impartial authority. So while some of the laws do say that if the person under guardianship wants the guardianship to be reviewed, that can happen, this says that there has to be a regular review of the guardianship, like on an annual basis, for example. That would be good. What an idea. Finally, states must ensure the equal rights of persons with disabilities to own or inherit property, to control their own financial affairs, and to have equal access to bank loans, mortgages, and other forms of financial credit. Countries must also ensure that persons with disabilities are not arbitrarily deprived of their property. And if you want more information, you can check out our webcast from November 2nd of last year to learn more. So Canada ratified the CRPD in 2010, but added a reservation to subsection 4 of Article 12. Canada reserves the right to continue the use of substitute decision-making arrangements in appropriate circumstances and subject to appropriate and effective safeguards.
Okay. I could understand one thing, okay? There is two reasons to have those reservations. It could be one, because our law are not made that way, and it takes time to change it, which is understandable within 1 hour, 1 year, 5 years, or 10 years, but it's not done. The second thing is you doesn't want to change.
Right.
So why do you sign?
I think the reservation has to do with not wanting to change the system. And again, when we get to this really ties very directly into our second topic, which is people's view of the quality of life if you have an intellectual disability or if you lose your memory. And the assumption is that you have no quality of life if you're not cognitively all there. So, and that's the idea. It's that you not only have no quality of life, but you also have no rights.
There is another reason. Try not to do too much politics. We are a federation, but healthcare is provincial thing.
Yep.
And the signing is for this the CRPD, the signing of CRPD is federal.
Yeah.
But the federal, if federal try to say to any province, you must do that.
Right.
The first province who go jump over that will be Quebec.
Yeah.
Because it will defend his right to do health care.
Right.
It's health, okay?
Right.
So, depending on what is your opinion of politics, and I don't try to do politics on that, this is very special thing, because for the federal could not do that, and if it could that, it will have a lot of problems, but even if you try to just say, okay, you must try to do something together, all provinces, it's not the same thing, because some provinces have many other problems to look for before that.
Right, and that's why Madame Devenda said in her statement that it's really important that provinces take up their responsibility for compliance with the CRPD.
Yes, and I agree with
on
that.
the rights of persons with disabilities. Okay. Canada also reserves the right not to subject all such measures to regular reviews by an independent authority. Where such measures are already subject to review or appeal.
Not a good idea.
Yeah, so basically they're saying that if the person has the option to request a review of their guardianship, then that should be enough. But the CRPD says it's not enough. And
it's already the case, and it's very hard to get out.
Right.
Yeah.
Right. And we see that it doesn't work. And anyway. Okay. So Ms. Devenda strongly encouraged Canada to withdraw the reservation and speed up the process to eliminate all forms of substitute decision-making across the country.
So 2 things. What about bias on the part of the people who are in charge of the appeals? I imagine if you go to have a guardianship order appealed, you'd have to work 3 times as hard to prove yourself and not get the authorities to look at you like, she has a disability, what is she talking about?
Right, and that's true
and
for
then,
the minority, actually. Yeah.
And then maybe I'm a cynic, but if you work for the government in any disability-related division, you're going to be thinking of protocol first, as opposed to like treating the person like a number, and you're not going to think in terms of independence and rights, because the system just isn't set up that way.
Yeah, and in fact, that's why it's so important that people with disabilities work in the field, because we're not only, because you're not only doing it as your work, but you're living it, and you get to see the results of the policy you make firsthand. And why it's so important not to have non-disabled people running these organizations.
I agree.
Okay, so each province has its own approach to guardianship and legal capacity. McGill University's Center for Human Rights and Legal Pluralism summarized them in a submission to the United Nations Committee on the Rights of Persons with Disabilities. And their summary was okay, but it wasn't that detailed. So I would suggest going to your provincial law and looking up the specific statutes, and we have links.
Yeah, there is links on every law.
Okay. So Manitoba's law recognizing supported decision-making only applies to people with cognitive disabilities. It does not include people with psychiatric conditions. British Columbia's law allows a representative to act as a bridge between the disabled person and any third parties dealing with healthcare, personal care, legal affairs, and financial affairs. As a safeguard, financial decisions must involve a monitor or at least two representatives. So there's a safeguard built in, but generally safeguards
Not to work.
don't prevent problems.
No.
There's usually plenty of problems to go around. Alberta's law only covers supported decision-making related to personal affairs rather than property. And Quebec has two types of guardianships. A tutor legally represents someone who partially or temporarily lacks capacity. The tutor does not need to represent the person at all times. It is possible for the person to make some decisions with no involvement or assistance from the tutor. And the other option, of course, is a curator, or more literally a guardian, represents someone who lacks capacity permanently and in all areas of life. Tutors and curators can look after the person's daily affairs, their property, or both. Tutors must preserve and maintain the person's home and furnishings.
And I know some tutor who think they are curator.
Yeah.
Even to go out of a tutorial thing, it is very, very, very difficult.
Right. And in Quebec, we'll talk about in a second, there's a safeguard in Quebec that's supposed to work, prevent abuse, and it doesn't work. The tutor or curator must approve any proposed medical treatment on the person's behalf, making sure that the treatment will benefit the person, is appropriate given the person's circumstances, and that any risks are proportionate to the potential benefits.
But there is problem about that because there is some kind of conflit d'intérêt.
Conflict of interest.
Yeah, that's okay, something.
Yeah.
It's a conflict of interest. Many things. Because what want the tutorial person and what want the other people who are
Right.
the people supervised, sometimes it doesn't need the same thing.
Right. Right. And what a non-disabled guardian thinks is in the person's best interest might not be the same as the person's.
Not at all.
Okay, and the tutor or curator must also represent the person in any legal action. Taylor?
Sorry, I was 2 lines behind you. So how many people within the medical system would recognize the right of a person under guardianship to refuse treatment? And if you're in need of some kind of medical treatment, how well can you assert your right under stress? I imagine a lot of people would just brush the person off. Again, she has a disability, therefore she doesn't know what she's talking about.
Exactly. And that's a very common problem. And, especially if you're under emotional stress or psychological stress, you're trying to function in this, if you're dealing with a psychiatric disability, you're in a stressful situation, that makes it that much worse. So, and people are treating you like you're, incapable, which is just exacerbates it. Okay, a tutorship council, which is the safeguard I was mentioning, made up of 3 relatives or friends, supervises and helps the tutor or curator, it's supposed to anyway, including outlining what the tutor is authorized to do for the person in their care. The council can also ask provincial courts to replace a tutor who is not fulfilling their responsibilities. I wonder how often that happens.
That is in theory.
Yeah, in theory. Okay, Ontario has 3 laws related to decision making. The Substitute Decisions Act deals with property management, personal care, guardians, and powers of attorney. Under this law, capacity is linked to cognitive abilities. Either you have it or you don't, rather than capacity being recognized as inherent in all people. So it's like either you have 4 cups of capacity and you need 8 cups in order to be at full capacity. So, you don't have enough.
If you pass a test, probably most of us will fail.
Right. Therefore, people whose conditions cause changes in their decision-making abilities are not accommodated because they're automatically out of the game. Nothing prevents a person's capacity from being called into question under the Act just because they have a disability. And it often happens that people with communication disabilities, especially people with speech deficiencies, are considered to have cognitive disabilities and considered incapable. So they're automatically considered unable to manage their affairs.
Which is not the case.
Right. The Healthcare Consent Act deals with consent to medical treatment and admissions to long-term care homes. And the Mental Health Act concerns a person's ability to manage property when entering or leaving a psychiatric institution. So, guardianship can be a life or death matter. The events surrounding the 2005 death of Terry Schiavo flowed directly from a conflict between her husband, who had guardianship over Terry, and her family, who believed that as a disabled person, she had a right to life-sustaining treatment.
Which one do you believe?
Yeah.
The husband or the family?
Yeah. And her family had their problems.
Right.
But when a guardian decides to cancel all of your medical care and you're supposed to be in a rehab facility, there's a big issue there.
Right. And he's spending the money that's supposed to go toward her treatment on legal fees to get the treatment withdrawn. That's
just at the other
That's messed up.
Right. That's just not right. Questions surrounding supported decision-making when a person is suicidal or asks for assisted suicide and euthanasia have received little attention, but they're really important. Yeah. So we're going to ask some of those questions. We can't answer them. They're not easily answered, but they need to be asked. What is the relationship between the dignity of risk, which is disabled people have a right to take risks and do stupid things just like everybody else, and a person's desire to intentionally harm themselves? If
somebody has never ever do anything
dumb,
let's say dumb, lift your arm.
Yeah. All right. What if the person's desire for assisted suicide or euthanasia is a symptom of the impairment that limits their decision-making ability? And we got into that issue when we talked about euthanasia for psychiatric
reasons.
And if, if a person is has depression, and that is dictating their desire for assisted suicide, what does that mean in terms of their ability to make good decisions for themselves? And if the person is subject to a substituted decision-making system, The very fact of being under guardianship might automatically make them ineligible for assisted suicide or euthanasia. Is that a good thing or not? Can't say, you know, it's not easy to answer these questions. And finally, what safeguards will ensure that the party who helps make the decision values the disabled person's life enough to pursue suicide prevention or other alternatives to assisted suicide and euthanasia?
A blanket ban on only this, excuse me, only on one procedure due to a guardianship order is probably going to be called discrimination, and rightly so. I'm not sure. With that last question, it seems like you're trying to legislate a mindset, which I don't think you can really do.
Right.
And
with the last question, I'm asking a question. I'm just raising issues here. I'm not trying to do anything.
We're not looking for answers. Okay.
Even if a question could be not in the line of what we think, it may be asked.
Right.
Yeah. And on top of that, what about stereotypes about happiness? The idea that some people with intellectual disabilities are happy all the time, or people who don't know how communication disabilities affect someone. They might not be able to say I'm in distress, but can other forms of communication be read and distress be detected in time?
Right. And that's why laws that deal with accommodation of communication talk about effective communication. And that, you know, I think about that term a lot, which was a term of art when I learned about the Americans with Disabilities Act. I think about that phrase when I read the writings of autistics who talk about their gestures, which are communicating something, but what they're communicating is not obvious to the people who are receiving it. So, yeah. The idea is to enable people to communicate what they're actually feeling.
Right.
Okay, so the second topic, Cadotte sentenced to 2 life terms. That's a wishful thinking. Excuse me.
2 years.
2 years.
There we go.
For manslaughter.
That's a kind of
2 life terms we wish.
That's a kind of standard sentence, because if you got 2 years and more, you go to a federal institution. If you are
under 2 years,
you go to a provincial place.
Yeah.
And normally, if you are very violent, you go to the federal place in general. And if you are not, normally you go to a kind of less violent place.
Yeah. Okay. So, pardon my Freudian slip. Cadotte sentenced to 2 years for manslaughter. Michel Cadotte, who was convicted of involuntary manslaughter in the suffocation death of his wife, Jocelyne Lizotte, in February of 2017, was sentenced this week to 2 years in prison and 3 years probation. The judge in the case called Cadotte's actions a quasi-murder, since he intended to kill his wife, even if his state of mind was affected.
What the rights on homicide.
Right, but the thing is that, you know, I guess it isn't really murder if she has a cognitive disability. I'm sorry, that's not correct.
Yeah.
Excuse me, Madame la Juge. Meanwhile, a soon-to-be-released expert report is expected to recommend that Quebec allow euthanasia by advance directive, even if the person is unable to verify that they still want to die when the time comes to be killed. So there's 2 things there. One is everybody here in Quebec is acting like this is consensus, that of course nobody would want to continue life if they couldn't remember who their kids were.
Which is not true. Most people will still like to live.
Right. And also, I think it's very likely that the health minister is just going to change the law without making it go through a process of the National Assembly, which would, for the second time, be an undemocratic modification of the law around euthanasia to expand it. And we know what happens when it's called a slippery slope. Okay.
Yeah.
Okay, if you want more information about the topics that we discuss here, you can visit our Facebook page at facebook.com/toujourvivant, not dead yet. You can visit our website at tvndy.ca. You can send us an email at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Christian and to Taylor for helping out.
Thank you, Amy.
And thanks to you all for being there. We will see you next time.
And a real cat video. Bye.
Bye.